Case of followed by the Registrar of Societies Act, and the last one will be on building and enhancing roles of domestic workers to the is with the Ministry of Human Resources. He joined the service in 1981, and from then to 1997 he was an enforcement officer of the Ministry of Domestic Trade and Industry, which is not the Human Resource Ministry. In 1997, he was with the Labour Office, Kuantan Labour Office. Or headquarters, with the Ministry of Human Resources. Yeah, that's when I came to know him also. So he used to, in the union formation, the Harris case, he used to sit quietly in one corner. So I thought, how come this guy is sitting there quietly? Yeah, he used to sit very quietly in one corner while a heavy discussion going on in the ministry. So suddenly I said, well, he's a spy or something. And he doesn't say a single word. So now he's an officer with the Ministry of Human Resources, Department of Labour, and he's a key man in many decision-making process, and also takes part in many discussions and giving information and from the and also giving clarification of ministry's stand and policies. So today he will be talking on the Employment Act and the Compensation Act. The other speaker on my left is Miss Annie Santiago. You all must know her because she's very familiar face among foreign workers and domestic workers. She's a national project coordinator for the ILO Triangle Project, the tripartite action to protect and promote the rights of migrant workers. The ILO Triangle Project is a regional initiative to assist in the regulation of recruitment practice and improving the workplace for migrant workers. The project aims to strengthen policy, build the capacity of stakeholders, and provide support services to women and men migrant workers and potential migrant workers. The project is operational in Myanmar, Cambodia, Laos, Vietnam, and Thailand, with Malaysia as the receiving country. Ms. Santiago is a lawyer by training and specialized in industrial relations law. She's a graduate of Warwick University and holds a master's in law and development. So you have a very highly academically capable person among us. So we shall start the discussion with Mr. Kesavan, and he will present his paper on Employment Act and Compensation. Thank you.
Thank you, Mr. Bruno, for the brief introduction. Good afternoon, ladies and gentlemen. On behalf of the Department of Labour and the Ministry of Human Resources, we thank you for inviting the department and the ministry to share with you some of the to share with you the Employment Act and what are the aspects, what aspect of the Employment Act that has some provision pertaining to domestic servant. But in the Act, it is known as domestic servant. But there were quarters who were urging us not to use the word domestic servant. Okay, but we still, because the law has not been amended, we still have to maintain it for the time being. So with that note, this Act, though you might say it is a 1995 Act, it's an archaic, it's a very, very old Act, but nevertheless, the department or the ministry has, as and when need be, we have made the amendments to the Act. And there were some quarters, though it's a 1955 Act, it has gone through at least about 11 amendments, and the latest amendment was done in 2012, whereby we made some alteration and included some provision and giving the Minister of Human Resources under Section 102M to make regulation pertaining to the terms and condition of domestic servant, which we will go through later. Okay. Now, if you look at them, okay, Employment Act, as you all know, its objective, I'm sure most of you being unionists, you all have negotiated, you all are representing employees, you all are well aware of the objective. Meanwhile, just let me. So this objective, I'm sure later these slides will be emailed to you or what by the organizers. You can go through. Set the minimum benefit. Minimum benefit here is pertaining to maybe annual leave, sick leave, maternity leave, hours of work, all of these kind of benefits that ought to be provided by an employer to an employee is stated in the Act. Okay, any violation of the employer who do not give or provide this minimum benefit, then the employee can complain to the department and we take action against the employers. Okay, the number of cases actually dealt by the Department of Labour throughout Peninsular Malaysia is about 15 odd, around 15,000 cases is been heard by the Department of Labour on various aspects, various complaints, various aspects of pertaining to the Employment Act. Now, to give sufficient protection, I've already mentioned to you against exploitation. Not every employer is an angel. We still have very unscrupulous employers here. Okay, sometimes there's abuse, exploitation, and whatnot. So when we get complaints of that nature, we deploy the officers to go down and then investigate and take whatever action need be under the provisions of the Employment Act. And third, redress to employees, and as I mentioned earlier, employees who have problems, they come to the department, and where whatever means, either by way of enforcement or by way of through the labor court, we try to address the problem and resolve the problem between the workers and the employers. There's an avenue for workers to come over to the department to seek redress, and wherever possible, we try to help and rectify the situation. And finally, like any other law, there is punitive provisions. Any employer, even employee for the matter, and there are certain aspects, employees also have their obligation under the Act. Whoever who fails to follow whatever provisions provided under the Employment Act, then punitive actions can be taken. This is generally what I'm trying to introduce to you, is pertaining to the objective pertaining to all employees under the Employment Act. Okay, move on. Then the Act applies to private sector workers only, and the Act applies to West Malaysia, Sabah, and Federal Territory of Labuan only. The Act does not apply to Sabah and Sarawak. Okay, because Sabah and Sarawak, they have their own labour ordinance. Okay, Sabah Labour Ordinance and the Sarawak Labour Ordinance. There were talks at one time to merge all these. Why we want to have separate acts according to regional or geographical location, but then we need to convince the state authorities that okay, we have one uniform. At the moment, they are not very receptive to that idea. So we have to hold on, okay, to have one uniform act to cover both Sabah and Sarawak and Peninsular Malaysia. Okay, besides that, the Act covers who are the employees who are covered under the Employment Act. Okay, wages, employees, okay, whose wages do not exceed 2,000 per month. So, and the other category is, one is irrespective of wages. That means anybody who earn 2,000 and below are covered irrespective of their occupation. First limb of the definition. The second limb is about irrespective of
wages, so long as they are employed as manual, who operate any mechanically propelled vehicle, manual supervisors working in a ship who's not an officer, and domestic servant. So from here, you will realize that domestic servants are covered, are defined as employees of the under the Employment Act. Okay, first thing you have to take note of that. Haven't settled it? Huh? Do you still have problem? Okay. Then, what is the definition of domestic servant under the Act? So first thing you have to realize that under the Employment Act, domestic servant, sorry to use the word, until the law is amended, we still have to use whatever terminology that is granted there. So, a domestic servant means a person employed in connection with the work of a private dwelling house, okay, and not in connection with any trade, business, or profession carried on by the employer in such dwelling, and includes a cook, house owner, butler, child nurse, valet, footman, gardener, washerman, washerwoman, watchman, groom, driver, cleaner, and blah blah blah. Oh, let me catch my breath first. Huh? And then it goes to what you mean by foreign domestic servant. Okay, means a domestic servant who is not a citizen or a permanent resident. So from here, ladies and gentlemen, you will realize that the domestic servant definition is very, very wide. Okay, it doesn't not comprise to only maids who are working in a dwelling house, but it also comprises, look at the definition, gardener, footman, and all this. So now what we have done in the 2012 Act is that we incorporated another new provision, okay, under the which came into effect on 1st April 2012, just to cater for foreign domestic servants. Means what? A domestic servant who is not a citizen of Malaysia, because we want to later introduce a regulation plus certain provisions we want to govern in that particular, in 2012, we brought in what a definition to distinguish between domestic servant and a foreign domestic servant. Okay, next. Okay, if you look at the schedule of the Employment Act, you might wonder that, oh, since I'm an employee under the Employment Act, or I'm an employee under the Employment Act, thus all the provisions that are provided, all the protection, all the benefits that are provided under the Employment Act must be available, must be given to the domestic servant. No, because if you look at the schedule, though it classifies the worker, the domestic servant as an employee, but this provision from section 12, 14, 16, 22, 61, 64, part 12, part 9, sorry, and part 12, and part 12A. Okay, these are not applicable to for a domestic maid. Okay, so when these are excluded, I'm sure most of the provisions here, the protection granted here, and these are excluded, thus there is no question. The department cannot, when the law itself doesn't give you that provision to take or provide the benefit, the hands of the department is tied. Okay, clear? Any question on this? Or you want to reserve the question later? Don't ask me why. We are just the implementers. Am I right? Yeah, no. Listen. It's not a laughing issue. Yes, when they come, oh, they demand this, demand that, demand that. But when the law is like that, what are enforcers or enforcement officers or labor officers going to do? Okay, unless this is put forward into the parliament, amendments are done, until then, our hands are tied. Okay, especially if you talk about rest days. Now all of you are saying, why you all can't give a rest day to us? Why not? Yes, I also, I mean, I'm generous, yes, I think all this got to be given, including the retirement benefit, but the law is like that. Okay, any question?
Later.
Okay, next. Okay, yeah. So this, if you look at the schedule, where the definition of employees are given, these parts are not to be included. Okay, then there's a provision under section 57 which says the termination of contract. When there's a termination of contract, okay, where the employer or the employee wants to, the domestic servant wants to terminate the contract, the date, maximum date, or the duration is 14 days. Okay, unless the employee's contract has an express clause providing for an alternative notice period. Okay, next. Okay, and now because of the introduction of the foreign domestic servant, we were able to bring in this particular section 57A and B, which says that when you employ an employee, a domestic servant, or when you terminate because of these reasons given, you have to give the department 30 days notice. Why we want to give all this, provide this provision is that so that we know, we can monitor. And it is not easy, ladies and gentlemen, especially walking into a dwelling house and at weird times, it is not easy for enforcement purposes. So in that order, we created this particular section. That means every employer who employs a foreign domestic servant, foreigner, must report to the department. So we know, okay, this particular servant or maid, sorry, don't use the word servant like it's not. The maid is here, working here, and whatnot. Okay, this first provision. Second, go on. Payment of wages, because there were so many cases and complaints to the department that foreign maids were not, or even local maids were not paid salary. Thus, we introduced this under Section 25 to enable an employer or ensure or make it mandatory that salary of a domestic servant or employees, whoever local or whoever covered under the Employment Act, must be credited into the bank account to ensure that the salary is paid monthly. Okay, otherwise, if the employee, if the servant wants it cash or by check, then she must require that particular request it from the employer, and the employer must get the approval of the DG in order to make payment via check or by cash. This to safeguard the domestic servant's salary and whatnot. Next.
What's the time limit for payment of wages?
Payment that is provided under the Employment Act, Mr. Narayanasamy, 7 days, that is, you are still applicable. But only thing, we have made it that you have to pay into the account. Okay, next. Okay, this is a provision, this is quite important. This is a provision in 2012 we introduced to enable the minister to make regulation under 102M of the Employment Act to protect the domestic servant. And that regulation only confines to terms and conditions. And we have drafted it, I think we have already put it in this thing. We have also got feedbacks from all the relevant NGOs and government agencies. And now we are in the midst of tabling it with the AG. And then if the AG agrees in everything and we can get the consensus from all the stakeholders, then we'll be able to introduce that regulation. Briefly, this is still, please ladies and gentlemen, this is still in the pipeline. I shouldn't say pipeline, it is still in the drafting stage and we are still negotiating and getting feedback from every party concerned. Until then, I hope you will get this right. Whatever, it is still in the drafting stage. Okay? Can you go on to the... Now what we are proposing in the regulation, proposed regulation, to contain duty of the employer to furnish a written terms and conditions of employment containing all this. I mean, details of both domestic servant and employer should be in that particular regulation, in the contract that the employer must give to the employee, and then address of the employer and the usual place of work. This quite rampant. We get complaints saying that my place of work is here, but when the employer goes for a vacation to the mother's house, he also takes me and makes me work there. So no, it's not easy to control this kind of thing sometimes. Okay, later we will see. And then commencement date, like normal other contract of service or employment letter, amount of wages, mode of payment, weekly rest days, provision for food and accommodation, terms of repatriation, termination of contract and notice period, medical expenses. Go on. Okay, provision relating to accommodation and meal, other items and conditions, domestic servant to be engaged in household duties and at the designated place, regards to the sensitivity of religious belief, should be able to, the employer should be able to give a opportunity to communicate with the family, rest days, repatriation, offences and penalties. This is the proposed regulation which we intend to introduce to cover for foreign servants or foreign maids. Okay? The important thing is the contract. So as I told you, we have already got feedback from various organizations and also the government agencies. I am quite confident because I was with this for a while. I think if you can introduce this, I think a major chunk of the problems of the domestic maids, I don't know how many will agree or disagree, but from the government point of view, we are quite confident that if we are able to come out with this regulation, I think maybe we can't solve every problem, am I right? We can't envisage any problem, at least about 60 to 70%, yes?
No, because we are excluded.
Huh?
No, because we are not we're excluded in that, we foreign domestic workers are not,
Excellent, yes.
it's still a problem.
Yes. But then at least wherever you are excluded, but by this regulation, some of the benefits that are provided under Part 12 are already mentioned here. Okay? Okay, next. Employment of foreign workers, I think most of you know about it. This general pertaining to foreign workers. That if you have a foreign worker, you must inform the department within 30 days. There shouldn't be any, if there's a complaint of discrimination, the labor department can investigate. Discrimination against a foreigner and a local against a foreigner, which is also happening. Next. Okay, no local employee may be terminated and replaced by a foreigner. Any employer guilty of such practice has committed an offence. So when in your employment, this is in general, it's not pertaining to dwelling house or pertaining to domestic servant. Generally, for foreign workers, this will apply, not for foreign domestic servant. And then where redundancy exists and a retrenchment exercise is conducted, foreign workers must be retrenched before locals if they are working in similar jobs. So on the workmen compensation scheme, I just don't want to deal very much. It is a scheme provided under the Act. You can read up in the notes. Provided in the Act to provide for a scheme, and every foreign workers, must be insured. Okay, per month the employer has to pay out $72 to protect for any injury or death. That's in a nutshell. Okay, any complaints, we will investigate and take up action. So what was the issue about this was that there were quarters who said that foreigners must be paid the same or given the same protection like what is provided under the SOXO Act. So we are now trying to study the issue, okay, because of the inequality, conventional inequality that has already come up. So we now studying whether we can cover the foreign workers. At one time we were covering the foreign workers. SOXO was covering. I think some of the senior, people who are in the union and in this area will know SOXO was covering the foreigners, but because we had some administrative problems, especially to pay the invalidity pension and whatnot, because after 5 years they are covered by SOXO, they go to their places or place of origin, and there were sometimes false claims also being made. So and then we couldn't monitor and then take action. So as a result, so they said, okay, I think in 1972, I think, the SOXO stopped covering the foreign workers. 82. 1993, thank you, 93 we stopped, okay, and then all this particular thing was put under the workmen compensation scheme. Okay, so with that I will stop my presentation, and later if there are any questions, I'm sure there are a lot of questions. All of you are very eagerly waiting to back me out of jail. Okay, it's okay, I know Solomon, I've gone through the bill. Okay, but if that is the law, that is the law. I can't bend and do anything to do anything. Okay, if that's the law, that's the law. Okay, you have to take it up with the certain quarters and make the amendment and empower us to do the work. Okay, so with that note, thank you very much.
Thank you, Mr. Kesavan. Short but concise. Any questions on Mr. Kesavan's presentation? Or should I take the questions at the end of all the presentation?
Better
Or-
take it now, then I can go back home.
So then the question is, shall we let him go now or no?
No problem.
Okay, now I shall ask Ms. Annie to make a presentation. Thank you.
Good afternoon, everybody. I'd like to thank MTUC for inviting the International Labour Organization to contribute to today's discussion, where the discussion here today is looking at whether we have adequate laws to combat human trafficking, and I understand that you have covered to a large extent in the morning. And I'd also like to acknowledge the presence of government officials and also participants who have dedicated passionately towards the cause of promoting decent work for domestic workers. At times I'm going to be breathing a little heavily, not because of the situation of domestic workers. I'm recovering from a flu, so just bear with me. So we'll just wait for them to start. Okay, basically, until the slides come up, I've been asked to speak on building and enhancing roles of domestic workers towards decent work. Yeah. So we will look at the ILO Convention 189 and Recommendation 201. And are we getting anywhere here? Okay, that's the title. Let's go to the next slide. Okay, basically what I'm going to be doing is looking at the convention and recommendations concerning decent work for domestic workers. Then we will go on to look at how what kind of steps that the campaigns can take for decent work for domestic workers, and what is the respective roles and responsibilities of the different stakeholders. Next slide. Okay, some problems with technology, but we just go on. Okay, now the Domestic Workers Convention 2011, or known as Convention 189, it concerns promoting decent work for domestic workers. It was adopted on 16th June 2011 and came into force in 2013. Okay, why do we actually look at conventions? When we have discussions at the national level, what is the importance of looking at conventions? Basically, when a convention is discussed, it has the involvement of the government, the employers, the workers, the tripartite constituents, who actually discuss, and they have many meetings before they actually arrive, what the minimum standards will be in protecting a particular sector. And here is the domestic workers. So that's why it's very important for us to refer to these conventions, because it basically sets out minimum standards agreed by the tripartite constituents. Okay, let's go down into the convention itself. In brief, what does the convention say? It lays down minimum standards. Here will be the right to join a trade union, which MTUC is working at it. And you also have the elimination of forced labor, and that's the topic for discussion for today. and also it also looks at child labor and also reducing abusive, exploitative situation for domestic workers. So that is the basic human rights protected under the convention. And what happens when the convention is actually ratified by the government? What role does the government play? The government actually commits itself in looking at the existing laws and regulations, and it also can progressively adopt the measures to promote decent work. And in terms of recommendation 201, it provides guidance on how to apply Convention 189.
Just follow that style.
Okay, now for as what Mr. Kesavan had set out under the employment regulations, what are the areas that the employment regulation covers? In terms of the ILO standard 198, what are the 189? What are the key elements that the convention covers? It looks at providing information on terms and conditions of employment, the hours of work, remuneration, occupational safety and health, social security, standards concerning live-in workers, standards concerning migrant domestic workers, private employment agencies, dispute settlement, complaints and enforcement. And as we go down this list, you will realize that you would have encountered in your work a lot of issues regarding one of this standard which has been already provided for. And I'm not getting into the details of every standard because that takes a lot of discussion, but during question and answer, if you want to know more about a particular standard, say in terms of hours of work, what should be the hours of work for a domestic worker, then we can go specifically into the article to see what the hours are. But you will have all the articles already stipulated next to the elements which has been set out, so you can also refer to it in detail later. Next one. Okay, why is Convention 189 important? Okay, globally we have 50 million domestic workers, and over $8 billion is in profits made out of forced labor of domestic workers. I can rephrase it, but I'm just going to use that sentence here. Okay, so basically there are, from the victims of forced labor, there's profits to be made and the amount is 8 billion. And 1 in 13 women are or is a domestic worker. And let's look at it in the Malaysian context. What do we have in Malaysia? There's estimated at least 400,000 domestic workers. We have domestic workers from Indonesia, Cambodia, Sri Lanka, India. And what happens if there's no adequate protection? Yeah? It can lead to exploitation, abuse, forced labor, and trafficking, the topic of today's discussion. The government of Malaysia, to strengthen protection for domestic workers, has implemented the employment regulations, as already been stated by Mr. Kesavan earlier today. Now, what needs to happen as well when a law is introduced? It's very important to consult stakeholders, and the Ministry of Human Resource has posted the regulations on the website for feedback and comments, and I believe the Domestic Workers Coalition has provided comments, the ILO has provided comments, and all these comments have been already provided to the ministry, and we'll wait for the ministry to see what are the comments which has been accepted. And one of the also standards which is stated in Convention 189 is there needs to be adequate consultation with the employer organization, workers organization, and organizations representing domestic workers. There needs to be adequate consultation before the regulation comes into effect. So basic, no, I'm not finished. So what needs to happen is the current regulations need to be reviewed, and that's another particular legislation that we need to look at as well, is the Private Employment Agencies Bill 2014. That legislation has been repealed. A new legislation is coming into force, and how does it protect domestic workers? Okay, and we so in moving forward, we also see the scenario in Malaysia. There is an embargo in terms of domestic workers coming into the country. The Cambodian government has a moratorium, and the domestic workers are not coming in from Cambodia. But I understand currently there's an MOU in discussion between the government of Cambodia and Malaysia in terms of recruitment of workers, domestic workers. And Indonesia had a ban some time ago, and of course all these bans come in because of high reports of abuse and exploitation. And commented how effective are those new terms. Is it working in terms for the domestic workers? Okay, next slide. Okay, how does the convention itself, how does it help the domestic workers? As we saw earlier on, the basic rights are guaranteed. So we saw the basic rights is basically for them to join a union, to be, to ensure that they don't work in conditions of forced labor, like long working hours, unpaid wages, working without rest days, restraining of movement. So we need to, the convention protects them from those situations. And inclusion. Basically, in Malaysia, it's also the laws equally protect migrant workers and migrant workers and the national workers. But it's the situation as such. So we need to fall back on the equality of treatment when we pursue a campaign for domestic workers to bring up the concept of or principle of equality of treatment and advocating the rights of migrants. Shapes legislations, I think also was stated by Mr. Kesavan. Okay, what are the principles and standards in the convention? Provides minimums which laws should comply. So we need to look at, see whether the new employment regulation complies with the standard. Accountability. Accountability in the sense that the regulations, policies are created and enforced by courts. There should be a monitoring mechanism. Under the MOU between Malaysia and Indonesia, there is a monitoring mechanism. There's a joint task force. Mr. Kesavan can probably tell us a bit later. And we need to know exactly what the task force does. Yeah? Do they meet? Do they enforce those agreements? And it also talks about how does it help? Enshrining rights. Okay, when governments change, legislations could change. So to make sure that that doesn't happen, the rights of the so to ensure that the working conditions of the domestic workers doesn't worsen, it's good to ratify the convention. Next slide. Okay. In terms of the countries that have ratified Convention 189, and you will see, okay, why are we jumping to ratify? Are we doing that? Or why is the importance of ratifying a convention, and what's the sequence, the consequences of ratifying a convention? Okay, these are the countries, developing countries on the slide, which tells you who have ratified the convention. And UMI is upper middle income countries, upper middle income developing countries. UMI is under middle income developing countries. And these countries have ratified the convention. And following from ratification, let's see what kind of protection that has come into place by forms of new legislation. And I'm quite dependent on the notes up there because the different countries have brought in different better protections. Okay, let's look at the Philippines, 2013. They have introduced a new law. It requires... Oh, okay, we have a friend here who knows what's the name of the new law. What bill is that? Okay, Kasambay bill. Okay, that's the one. So we have participants here who have more information, and probably they can also share a bit more later. And you have improved minimum wage, social security, and public health insurance for an estimated 1.9 million domestic workers. And what is important here as well, it prohibits recruitment fees and made employment agencies equally liable with employers if there are situations of abuse and exploitation, or for provisions of wages and benefits. Let's look at another country in South America, Argentina. They ratified the convention in 2013. they have now a maximum work hours of 48 hours per week. That is what the national, in Malaysia, you have the maximum of 48 hours per week. Yeah, that's for the national workers. In Argentina, they've also prescribed a weekly rest period, overtime pay, annual vacation days, sick leave, and maternity protections. In Malaysia, there's no maternity protections, you will be deported. Okay, and Brazil. Brazil adopted a constitutional amendment in March 2013, entitling 6.5 million domestic workers to overtime pay, unemployment insurance, pension, maximum 8 hours work a day, and 44 hours work week. Spain, in November 2011, set requirements for a minimum wage, weekly and annual leave, maternity leave, compensation. It's like also you have like, you find that domestic workers work for a long hours, yeah, and then in the afternoons they are not really working. It's something like a hotel industry. So, but here you have compensation for standby time when employees are working but are not working but required to be on call. And they've also incorporated domestic workers in the social security scheme. Venezuela, 2012, 40 hours per week, 2 weekly rest days, paid holidays, minimum wage for domestic workers. And I just want to touch on a very interesting case here. This is in Kenya, a court case, a decision by a court. And it's a landmark case, and this placed domestic workers under the protection of labor laws. And it extends to them getting the national minimum wage and social security benefits. So we can see after the ratification of 189, what the countries have done, what are the steps they have taken in terms of providing protection. And in a country in Africa, Kenya, the courts have made a decision extending protection to the domestic workers. And these are some of the examples that we can look at in terms of when we review our local legislations. Okay, I think we went through this. Okay, what do we expect when the government ratifies? Okay, basically you harmonize the local legislation. Okay, stakeholder consultations. I think, okay, this is quite important in the sense, we spoke who are the stakeholders here, key stakeholders, yeah, and the Convention 189 itself says you must look at identifying categories of workers who would be excluded from the scope of the convention. These are areas that needs to be discussed. And what are the measures on occupational safety and health, measures on social security, measures to protect workers from abusive practices by private employment agencies. Many of you encountered that quite a lot. And here, the convention clearly says that you need to have the stakeholder consultations, especially in these 4 key areas. Now, this is quite blur for me too, but let me see how this Convention 189, what is the role and what are the benefits for the different stakeholders? Okay, one, for the domestic workers itself, it raises dignity, respect, and recognition. What happens when you raise dignity, respect, and recognition? What happens? When you raise dignity, respect, you reduce abuse and exploitation. The second, it clarifies the responsibilities and improves rights, strengthens protection rights and redress mechanism. And if you go into the details of redress mechanism, okay, how does the domestic worker avail when she's in an isolated situation? And what's also very important here, allowing domestic workers to join a union. So some of these are some of the key areas which are relevant to the domestic workers. The next, for trade unions. It increases your membership, it strengthens legal right to organize, it increases bargaining power with employer and the government, and it also looks at shaping legislation. For employers, I think what is good for employers is actually to look at the contract of employment. That's very, very important, because as it's like we know that contract of employment from Philippines basically has better protection from workers who are coming from Indonesia. So employers play also a very important role in ensuring or providing their inputs into ensuring that minimum standards are included in this contracts. and also for the employers to gain clear understanding of their own responsibilities when they hire domestic workers, and what is there any penalties under the law? Mr. Kesavan said earlier in the morning that the employers are required to bank in the salaries, and if they don't, is there a penalty? So employers need to know those things, yeah, and it leads to improved employer reputation among domestic workers. And you also know that domestic workers do not have to leave the job and go to another job hopping. Yep. And last but not the least, the role of the government of Malaysia. It legitimizes to the creation of sound policy, improves relationship with workers, employees, other stakeholders, prevents future labor embargo. Yeah, from what we're experiencing. There's a lot of discussion because of the workers not coming from Indonesia. And I think there's a lesser number coming, though there's no embargo, but there's no workers coming from Cambodia, and the problems employers face. So you can, reduce this, and you don't have to face that kind of situation. And it also validates Malaysia's stance on combating forced labor and trafficking. Yeah. So basically, that's a discussion for today. Yeah. How best are we combating trafficking? So this is where the government of Malaysia can also. By looking at the convention itself and reviewing the employment regulation, also show that they have taken concrete efforts in promoting decent work for domestic workers, and in that way, in return, eliminating forced labor and trafficking situation. Okay, so now what's your work? Let's see. Okay, campaigning for decent work for domestic workers. You can take 3 approaches to doing this, yeah? And the first one, recognize, that's the first goal. Protect, third one. Reach out and organize. I think most of you are already doing this, yeah? You're doing it in certain ways, in different ways, and maybe now we need to think of how you want to go forward. Can I go to the next slide, please? I think you need to just keep doing it. Okay, firstly, when you are actually campaigning, what you do, recognize. You can recognize the ILO standards on domestic work to guide national policy and practice. The next one. National law and legislation that recognize domestic work as employment. I think that's what we want to do, isn't it? We need to do that. Worthy of regulation and labor law protection, benefiting both domestic workers and their employers. We also need to see that, because of course the ILO is also currently undertaking a survey in Malaysia to see what are the responses, what are the predicaments, what are the expectations of employers in recruiting domestic workers. So in that respect, you will want to protect, or you want to make sure that both benefit, both the employer and the domestic workers. And research and visibility through regular systematic data collection. I wonder how we are progressing at the MTUC level and NGO level in terms of the data collection. Okay, your second approach here or goal is to protect, campaign for services and mechanisms that directly address the needs for domestic workers. Now, what you can do, look at the regulations that it's still in the draft stage, and we're just probably going to move to the AG's chambers soon. You'll have to look and see what form of complaints mechanisms are there for the domestic workers. Is it effective? Can the domestic worker access that kind of complaints mechanism? Model contracts. What kind of contracts? There's a new regulation. We saw all the different elements that are in the employment regulation. We need to also see in the contracts itself, how are the wages going to be paid? What number of hours? What about the rest days? So we can look at those things. Labor inspection guidelines. Here, of course, the ILO says when you do labor inspection, you need to balance between the security of the household and the protection of the domestic workers. So these are some of the mechanisms that you want to review under the employment regulations. And of course, sometimes when we read, suddenly we will hear about a particular policy being announced, and we are not aware of this particular policy. So what is required is regular, so we don't have ad hoc policies. Next one. Educate and raise awareness okay, of domestic workers, employees, and the general public. Basically, I think a lot of raising of awareness has been done by the NGOs here and also the trade union to actually first, as a starting point, that domestic work is work. And the last, but not the least, reach out and organize. I also think that, I think maybe Silam would have mentioned it earlier, there's efforts to actually register associations, yeah, for domestic workers. So what do? Reach out and organize. Domestic workers need to know and claim their rights. This is very important. Why don't the workers exercise their rights? Because they don't know. And if they don't know, whose fault is it? Us stakeholders who have not informed them. Yep. So it's very important to raise, because they also work in an isolated environment, and so the outreach will help them. Domestic workers need to organize, join and form trade unions, negotiate with employer associations and the state for protection, bargain collectively. We may be a little far from all this, very far from that, because you know the laws and regulations and registering and recognition of trade unions in Malaysia is very restrictive. So how more for domestic workers? But this is what are the approaches that we take builds towards that. In conclusion, what I wish to say, basically Convention 189 and 201 influences changes in laws and improve the working and living conditions of domestic workers regardless of ratification. So we can take the approach, okay, yes, we can work towards ratification. It may be in the long run. In the short term, what do? So we need to have short-term strategies, long-term strategies. In the short term, now that you have the government to strengthen the protection for migrant workers, domestic workers, has introduced the regulation. So for the short term, it's important to review, yeah, and to also weigh against the ILO standards to say, okay, if this is working hours, does this conform with the ILO standard on working hours? If it's on rest day, does it conform? So this is how you match to see. Improving rights is a work in progress. So basically, I think it's a collective effort between all the stakeholders, and you need to prioritize, like what are the areas that you want to start with? Maybe coming out, firstly, now that you have the regulation, maybe you want to work together and looking at the regulation, or next you want to look at developing a model contract. But I think developing a model contract has been undertaken by the Bar Council, by Tenaganita and other NGOs. So maybe you want to develop further on that. And also like the current working hours, maybe you want to focus on that. So you can identify which area will be helpful. And also supporting victims of, like of course we have the case of Nirmala Bonet and so many others. And support these victims in high profile cases. And I think that's the conclusion. Thank you.
Thank you, Annie. So open to the floor for any questions. So either Kesavan or Annie. That's 1, 2, 3. We'll give you a mic. Give your name, where you're from, and your question.
Hi, good afternoon, everyone. My name is Joy, and I'm from Malacca. I belong to the Church Migrant Ministry Group. What I'd like to ask is, where domestic workers are concerned, it's very interesting to hear about how the employers are supposed to be banking in their pays and all that. But when the girls come into work, the first 3 months, the pays are cut. After that, the agents say they have to take some cut. So by the end of the first year, there's hardly any salary for the girls. So, and how many employers are aware that they are supposed to open a bank account? How many employers realize all that? Is that all being made, employers made aware of all this? Maybe Mr. Kesavan would like to answer this question, please.
Okay, thank you. You will take down the question.
Yeah.
Lorraine from Tenaga. Thank you, Mr. Kesvin and Annie, for your input. My question would be to Mr. Kesvin. Within the Labour Department, there is a Labour Trafficking Unit, or the Anti-Trafficking in Person Unit. I would like to know if you have the statistics of how many employers have been persecuted since the implementation, as well as what is really the mandate. This is because many of the times that we had gone to Labour Department and we want to file a case, we've been said, under the identification they are not trafficked. So if you can share with us what are the criteria in place, as well as the mandate or the SOPs for Labour Department within that unit. Thank you.
On labour trafficking.
That's right. Yeah. And in particularly where domestic workers are concerned.
So your question is, what is labour trafficking?
No.
What constitutes labour trafficking?
Well, no. What is the mandate of that unit within the Labour Department? Because I'm aware there is anti-trafficking in person unit within Labour Department.
My name is Leonila Taho. I'm working as a domestic worker here. My question is regarding the Employment Act. There's a certain, this morning it was discussed, there's a certain part about
Excluded.
it's about once the worker finished the employment contract, or even not finished, the employer will is obliged to bring the worker to the airport. So something like that. And my question is, because this makes us domestic workers very vulnerable to abuses, because like if we are not our rights is violated by our employers. Of course, we have the right to terminate the contract, or the employer is satisfied with the work services. The employer can also terminate our employment contract. But then we have, like if we are abused, then how can we file a complaint that our employer will bring us directly to the airport, and then we have no chance to file a complaint? So my question is, since the government, the Labor Department or the Immigration Department is having this kind of amendments for these articles, why not include the foreign domestic workers with these provisions that the local workers enjoy, because there are certain policies for the foreign domestic workers are specialized to only for us, that makes us more vulnerable to these abuses. So the question is, why is there policies that exclude us foreign domestic workers?
Okay.
So now that I've heard about the Convention 189, that it should be the foreign workers and the locals should enjoy the same rights. So I think domestic workers should not be excluded with these particular policies among workers, because we are all workers. Thank you.
You're asking why on termination of the contract?
Yeah, the exclusion of the foreign domestic workers.
In the Employment Act. In the Employment Act.
The Employment Act.
Good afternoon, and thank you for the presentation just now. My name is Karuna, and I'm from the National Union of Employees, MUBE. I just have one question for either Mr. Keswan or any addresses. In February 2008, the Bar Council organized a 1.5-day forum in collaboration with the ILO, and it was called Developing a Comprehensive Policy Framework for Migrant Workers. Now, in this forum, several stakeholders were involved, including the government and NGOs and trade unions. And there was a 20-point action plan that was actually put up and presented to the government. Can any one of you give us a brief 20-point action plan that was submitted to the government from the forum? Thank you.
Anyone else?
Hello?
Yes.
Hello? You switch off my mic. Okay. My question is directed to Mr. Kesavan. I'm in from MTUC. Recently we met with MEF. We were told by MEF stands for Malaysian Employer Federation. We were told by MEF there were 8 ministries involved in the recruitment of foreign workers, which include the domestic workers. The glaring ministry left out from the 8 ministry is Human Resource Ministry. Every ministry is involved except Human Resource Ministry. MITI, Home Affairs, blah blah blah, the other ministry. So, Mr. Kesavan, your comment on that. The other thing is, I've not seen any news report of any employer being successfully prosecuted for violation of the Employment Act for domestic workers. Your comment? So far, no prosecution, or somebody asked, what's the statistic? The other one is, I've read recently, there were 10,000 employers, news report 10,000 employers, who have not complied with the Minimum Wage Act, which includes also foreign domestic workers. Till today, we have not seen your ministry has or I say news report of your successful prosecution of any employer under the Minimum Wage Act. Yes, we have law, we have good law, but if you don't really enforce it, there's no point of having a law. Thank you.
Okay, thank you. So we'll start with the case one. Shall we start with you?
Thank you. Ms. Joy from Malacca. This amendment regarding the opening of account not only is applicable to the locals, it is also the domestic servants are also is applicable. And when a legislation is introduced, normally the department go on a roadshow. We go on a roadshow. We call employers in the particular respective state, employers, trade union, and NGOs, and we leave it to the host. I mean the department head to call or the parties or the stakeholders involved to this kind of briefings. Even when we introduced the minimum wage, we went on a roadshow. After the minimum wage and then the retirement age, we went on a roadshow, and we'll try to disseminate as much information as possible. Yes, I think maybe the thing is not enough. I think as far as the domestic servant and the employer to open up the account, I think it has not reached the state that it should have reached. Okay, so maybe we will take note of this. But generally, when an act is discussed and then is passed in Parliament, there's a lot of publicity given in the press, in the papers. What are the amendments? What are the employers need to do? And even MEF, I think after that will try to circulate what are the new requirements and whatnot. But I'll take note of this. Okay, thank you. Okay, the second question on anti-trafficking by we have prosecuted. We have a unit, known as the anti-trafficking unit, and there was a lot of, in fact, not to say objection. Some people feel that the labor department should not get involved in anti-trafficking. First, they say that you're a labor enforcement agencies, whereas anti-trafficking is totally a different crime. But then the government looked at the whole thing in total, and finally they included us as one of the four employment agencies into the act. I think section 26. I think we were included as an agent of trafficking. But our scope, please, is to make sure and to look at the labor exploitation part of it. And what we were briefed and what we were told that if an employee is not paid 3 months of wages, then it will be deemed as an exploitation from the labor point of view. And that's why we